Section 5, Escrow Management in Florida. The escrow account is an account for deposit of money that the broker holds in trust for others. The deposit is the money delivered to a licensee in connection with a real estate transaction. Earnest money deposit can be cash or anything that can be converted into money. To commingle is the illegal practice of mixing another's funds with broker's money. It is advisable to include the word escrow or trust in the account name. Escrow accounts are for the deposit of the money held in trust. For instance, sales deposits, earnest money, prepaid rent, security deposits, and etc. The escrow trust money is placed into the account until services are rendered. Upon completion of real estate service and broker has earned his compensation, it may be transferred to the broker's operating account. Brokers may not commingle, mix sales or rental escrow deposits with other type of funds. Commingling is mixing a buyer's, seller's, tenants, or landlord funds with the broker's own money, or mixing escrow money with the broker's personal funds or brokerage funds. Conversion is the licensee's personal misuse of the client or customer's money that deprives the rightful owner of property. Authorized depositories for escrow trust accounts, whether they're interest-bearing or non-interest-bearing, is in a Florida commercial bank, credit union, or savings association. If the broker chooses not to have an escrow account, they may use a Florida-based title company or Florida attorney. The broker must be a signer on brokerage escrow accounts. If there are multiple brokers, one broker may be the designated signer. Brokers may designate bookkeepers to sign checks in ordinary course of business. However, the broker is held accountable for any violation. Timely deposit means immediately. Sales and broker associates must deliver the deposit from the buyer or rental deposit from a renter to the broker by the end of the next business day. Brokers must deposit escrow funds no later than the end of the third business day after the sales associate receives the deposit. The first day of the 3 business day period is the day the sales associate received the escrow money. Broker is accountable for trust funds received by associates or employees of the brokerage firm. An example of a timely deposit would be if the broker associate received a rental deposit from the tenant on Friday and there's no legal holidays involved. The broker associate has until the end of Monday, next business day, to deliver the deposit to the broker. The broker has until the 3rd business day following the receipt of funds for the item to be deposited. In reference to post-dated check, the seller's approval must be attained before accepting. It should be noted on the contract as post-dated, and the broker must secure the check until payable and then immediately deposit in escrow. Checks that are returned for insufficient funds, the broker will not be liable if the broker makes a timely deposit. When the escrow account is interest-bearing, it requires prior written consent of all parties. They must agree on who's going to receive the interest, also when the interest will be paid. When the interest goes to one of the parties, the transfer of principal and interest to a non-interest-bearing escrow account, then writing a separate check for the principal and interest. The alternative method is a separate interest-bearing account for each transaction. When the interest goes to the broker, it can be withdrawn from the account each month. When the broker chooses not to have an escrow account and they elect a title company or an attorney to hold it, it must be indicated on the purchase and sales contract, the title company or the attorney that will be holding the earnest money, the name, address, and telephone number on the contract, not the email address. Within 10 business days after the deposit is due, the broker must make a written request to the title company or attorney for verification of receipt of deposit. Then within 10 business days after the broker made written request, it needs to be provided to the seller's broker a copy of the written verification. Brokers must keep at least one legible copy of business records, books, and accounts, and keep them in compliance with the Florida law and commission rules. Records must be preserved for at least 5 years from the date of receipt of funds or from the date of any executed agreement for brokerage services, even without receipt of funds, and must preserve the records 2 years beyond any court proceeding. The total sum of the deposits received and being held by the broker is referred to as the broker's trust liability. Sales escrow accounts, trust liability includes all earnest money deposits. Property management escrow accounts, trust liability includes undispersed rent, owner reserves, security deposits, and other funds collected that benefit the lessor or the lessee. Calculating trust liability sales escrow. Record of all receipts and disbursements according to the amount, date, buyer or seller information, and total deposits less the total disbursements equal the trust liability balance. There is allowed an amount of money that belongs to the broker to be put in the account to maintain the account. I like to refer to it as buffer funds rather than personal money, but they're one and the same. So with that being said, brokers may place $1,000 of personal brokerage funds in the sales escrow account. Brokers may place $5,000 of funds in the property management escrow account. Brokers must account for personal funds in the escrow accounts on a monthly reconciliation. It is not required, but it is suggested and recommended that property management escrow money be kept separate from sales escrow money. So let me stop right here and tell you something that could possibly be thrown on a test. Because they don't have to separate it and they can keep it together, it's not $6,000 of buffer money that can be kept in the account if it's both things in one account. Follow me? The maximum's $5,000. All right, just want to make sure you are aware of that in case you're asked the question. So, as we said, separate property management escrow is recommended. Rent and security deposits collected on behalf of the landlord. If check is payable to the brokerage, funds must be placed in the escrow account. After funds clear, the broker may disperse the rent to the landlord. If the broker has permission to deduct commission from the rent payment, the broker must transfer the commission to the operating account. The minimum information included on a monthly reconciliation statement would be the date the reconciliation was performed, the date used to reconcile the balances, the name of the financial institution and account number, the account balance and date, deposits in transit, outstanding checks, an itemized list of the broker's trust liability. In the monthly reconciliation, trust liability should equal the reconciled bank statement. If there's an overage or a shortage, there has to be included corrective action and an explanation. A negative balance indicates a shortage in the escrow account. Do not spend funds on behalf of an owner if the owner's funds do not cover the expenditure. Brokers could be charged with conversion. Disciplinary guidelines for failing to reconcile escrow accounts include a $500 citation for failure to reconcile each month, and that's only if the account balances. Shortage results in a formal complaint filed against the broker and will be prosecuted through the commission disciplinary process. Brokers must not disperse trust funds until the transaction closes or as directed and agreed to by all parties. Conflicting demands occur when the buyer and the seller make demands regarding the dispersing of the escrow account that are inconsistent with each other and cannot be resolved. To report an escrow dispute, conflicting demands, the broker must submit to the DBPR the form Notice of Escrow Dispute Good Faith Doubt. The form is available on the DBPR website and is a form fillable PDF that can be completed online. The completed form must be printed and mailed to the DBPR/DRE. The settlement procedures for both good faith doubt and conflicting demand is remembered by the acronym MALE, M-A-L-E, mediation, arbitration, litigation, or escrow disbursement order. Mediation is informal, it's non-binding. Arbitration is a binding settlement, and it's adjudicated by a third party. There are no appeals. Litigations when one of the parties decide they don't want to deal with it anymore and they're taking it to court. What happens then is the broker is going to file with the court either an interpleader or a declaratory judgment. If it's an interpleader, the broker has no financial claim on the trust money that's being seen in the court. Declaratory judgment, that's when the judge declares each party's rights to the funds and the broker has a financial claim. As we know, a lot of times at the end of the contract, the listing contract, it talks about if the seller retains any escrow money, that 50% will go to the brokerage and 50% goes to the seller. Now, it doesn't have to be that way. Some brokers don't keep any of it. But if they should decide to keep some part of it, instead of an interpleader, it would be a declaratory judgment. And then last but not least, E stands for escrow disbursement order, where the broker asks the commission to make a decision. So the process of an escrow disbursement dispute, the broker may request the commission to issue an escrow disbursement order. If the commission denies the EDO, the broker must use another one of the settlement procedures and must inform the commission within 10 business days if the dispute is settled or it goes to court. Good faith doubt is when the broker doubts either party's intention to act in good faith according to the contract. Notification to the commission in writing within 15 business days of having the doubt, and begin a settlement procedure within 30 days of having the doubt. Exceptions to the notice and settlement procedures would be HUD-owned properties, condominiums, and financing contingencies. This is the end of Section 5.